Okay, all right, second case on our docket this morning. Again, it's Tuesday, June 9, 2026, case number 25-0509, Donald Simpson versus 31070 Cortez Boulevard Associates, LLC, and Winn-Dixie Stores Leasing, LLC. Let me, Mr. Lee, before you get started, is the defense, are you going to split your time between yourselves?
Yes, Your Honor.
10 minutes each, or is there something different? Okay.
Yes, sir.
All right, Mr. Lee, you want 5 minutes rebuttal?
Yes, Your Honor. Thank you.
Okay, everybody ready? You guys ready over there? All right. Mr. Lee, whenever you're ready, sir, go ahead.
Good morning again to the court. Brian Lee representing Mr. Donald Simpson in this appeal. We are asking this court to reverse the summary judgments that were entered in favor of Winn-Dixie and Cortez. We believe the trial court committed error in granting summary judgment to both defendants on the issues of duty as well as on the issue of notice, knowledge of the particular substance, the water that was on the paint stripe, as well as the trial court's other finding within that this condition was an open and obvious condition, and therefore, because plaintiff could have seen it when he was walking in and then walking out, that precludes recovery.
You agree that one of the two defendants had a duty here, right?
I believe both of them did.
I know, but I mean, the orders that we got from the trial court, neither of them had a duty according to the orders, so I wasn't clear how that, I mean, they may have the fight amongst themselves down the road, but...
I'm not positive. I frankly do not know how the trial court got to that point because the trial court used the same lease and I think the same common law duties to say that this is part of the lease of Winn-Dixie, and therefore they have the duty, but this is part of the lease of Cortez, and they have, or they didn't have the duty. So so
he slipped on the sidewalk. Was that? I just want to be clear as to
right. So he's coming out of the store. He's at a level where the sidewalk kind of is sloping within it, and then there's a painted line that's sort of before it as it's sloping. He slipped on the painted line.
Not the concrete.
I'm sorry.
Painted line, not just the rough concrete.
That's correct, yeah. So the painted line that was there before the going into the parking lot. And there was some discrepancy, I think, that was largely resolved, that he tripped, because the evidence was very clear in his deposition testimony that he slipped on the line.
So let me ask you this question. Is Mr. Simpson's theory of liability in the operative complaint that someone on behalf of one or both defendants hosed down that area, creating the slipperiness on the painted line?
That was what he said in his complaint. That's correct.
Is there any evidence whatsoever that someone hosed down that area causing that condition?
No, there was no evidence that.
So how do we handle that? I mean, the plaintiff is the captain of his complaint.
Right.
The claim is limited to those set forth in the complaint. The complaint alleges a theory for which plaintiff has just conceded here. There's no evidentiary support. What do we do with that?
So the part about hosing down and did that was the part of the complaint that was supposed to address how the water got there. But they hosed it down, and that's why the water was there, and that's what the slip fall happened after that. You're correct that there was no evidence of there was a hosing down, but there was evidence, and I think was pretty undisputed by the parties, that there was water there on the stripe. Now, whether that's water from some other source, whether it's from humidity, condensation, whatever it is, there was water there on that stripe.
Well, he walked through that water, though, correct?
He walked, he walked, certainly walked through the area.
Okay, so he walked through the water, and then 7 minutes later, from the video, 7 minutes later, walked back out. So he should have known there was water there, correct?
Sure, and that could certainly go towards, I think, the part of the trial court's decision about open and obvious, right? Is this something that he should have seen coming into and going out? But open and obvious certainly could go to duty to warn.
So you're not disputing that they caused this then? Your theory now is that it's dew on the ground. I know they said humidity, but
Right.
probably, what time of day was this? Do you
This
recall?
was, I believe it was early to mid.
11 in the morning?
Yeah, it was very early, and you could see sort of in the general area where the sun. It was a sunny day, but there was a big area where there was water, whatever you want to call it, water, moisture, whatever it is, and there were footprints, tracks coming sort of in and out, at least from the people who had already been in the store.
So we're clear, I mean, there was no puddle there.
There was none. No. There's no evidence that there is a big puddle that's just is sitting there just by itself or something. But there is that.
Theory then, I mean, because obviously it rains in Florida in the summer.
Sure.
I guess this wasn't summer, but we wouldn't have a scenario that's simply because a parking lot, whether the owner or Winn-Dixie was responsible for the parking lot, because the parking lot's wet because it rains in Florida every day in the summer, that they are now exposed to liability if somebody slips on a rained-upon park. I mean, if there's a big puddle, I mean, I get that, but
Sure.
you can see that it's just water.
It's water on top of a
water on
stripe.
a surface, and it seems like your position is the line itself was the hazardous condition.
It was, and also, there is case law that I've cited to and throughout Florida that talks about ingress into a business. And so they talk, different than, there are parking lot cases, right, that talk about things such as potholes and, things. And they say, hey, look, sometimes those things happen in parking lots and they go kind of back and forth on it. But when we're talking about ingress, and this is very clearly egress to the store.
He's walking out the door.
And he's coming out of the store at that point, but he certainly came into the store. And the case law is pretty clear that they do have the duty to maintain ingress egress. And when you have water on a stripe, which we do think we contend would be a dangerous condition, they have the ability to that. It would be the same as if there was rain coming in and out, and there's rain outside of the door, and someone slips on the door. It doesn't have to be inside
Well, let me ask,
to do that.
I mean, if it was not the hosing would seem to be an actual notice. If I create the danger,
Sure.
then I'm on actual notice of it because I did it.
Right.
Whereas constructive notice, somebody else did it, I just should have become aware of it because I need to make sure my premises is safe for the customers or invitees, et cetera.
That's right.
I mean, but here if I'm understanding the direction we're going is, okay, this painted line was slippery when it's wet.
Right.
And that's the danger. Does that then take us to a scenario that there has to be some kind of notice to the tenant or the owner or both, or for my argument, let's say they're both responsible for this in some fashion. I know they have their arguments, but all right. Do they have to be on notice that is a dangerous condition so that they needed to rectify the slipperiness of the line?
I don't believe that they have to have notice of the paint stripe.
But they have to be aware of it. It's dangerous if it gets wet. I mean, because it will get wet because it
Sure.
rains in Florida. It will get wet. It's not a puddling thing, which has a different element.
Right.
It's just, okay, we have a drizzle, it's wet. Now we have a line that's wet. That's a slippery scenario, people. It's different than the rest of the parking lot. That's slippery, and it could be hazardous to your customers. You guys need to address it. You need to have less slippery paint. I'm not
Right.
trying to be facetious, but actually I think we had a case about this at the Volusia Mall not too long ago.
Sure. I think I see where you're going. The dangerousness of a condition, there isn't. See if I can say this in a constant way. There's nothing under Florida law that says that a store owner must know that this particular is a dangerous condition. Like they have to, like someone has to, there has to
You
be.
don't get a free first fall. is
Right.
what it
The
is.
store manager doesn't have to testify that, oh yeah, we knew that was dangerous and we knew that, when water got on it, it was going to be super slippery and we just didn't do anything about it. They don't have to know. That would be more actually actual notice. But so dangerous condition, whether or not something is a dangerous condition in the circumstances of what this is, of this scenario is typically a jury question. That's what the cases talk about when they talk about dangerous condition. Because it's not just a dangerous condition, meaning whether it inherently is a dangerous condition. It's whether it's a dangerous condition under the circumstances of the situation. There are some situations where something may not be a dangerous condition, depends upon where it is, right? And so those are classically jury questions. And when they bring summary judgment on things such as, or when the trial court does it, on open and obvious, an open and obvious condition presupposes that it's a dangerous condition.
So but here's my concern. What must be resolved by a jury, whether or not a defendant who creates a condition must actually know about it? That's an interesting question legally, and there's opinions from the First District Court of Appeal on that particular issue, and I think that may be an emerging question, but that's for another day.
Sure.
My question is more focused to this particular case and this particular complaint. The entire theory of liability is that this stripe became wet because someone on behalf of one or both defendants hosed down this area, and there is no evidence, concededly so,
right,
no evidence at all as to that allegation in the complaint. And I'm still back at the first question I asked earlier on in the oral argument. How is the court to address that reality? That's
Sure.
where I am. I understand where you're coming from as to the legal questions, open, obvious, what it presupposes, what a defendant must either actually know or constructively know, but what do we do with the allegations framed in the complaint, because that cabins the claim?
Right. And so when we're looking at, I'm actually looking at the allegation, was pulling them up as we talked. Yes, it does talk about the hose and the reason why the water was there. What it says is, as part of the negligence parts, that they failed to maintain it, or adequately maintain the parking lot. They also talk about that they create the conditions. So there's both. There are allegations that they negligently maintained it, but also so there's inherent within negligence claims like that. When you talk about both maintain and warn, we have to prove either actual or constructive notice. Actual notice would have been certainly, I think, as you've already noted, that if we had someone that said, yeah, I put water on that thing, that's actual notice of the condition of the water that's on that paint. What we also have under the statute, which there's either way of what it is, but even if
which statute are you referencing?
The transfer of foreign substance statute. I don't believe that.
So, but you argued that doesn't apply here, correct?
It doesn't, but
and you don't think it does because it says any business establishment, correct?
Well, inside the business.
Inside the business. Inside the business.
That's right.
So
But
the
even-
trial court analyzed this case under that statute, though?
I believe that I would have to look at I believe he did. Or yes, because that was part of what it was. Now, even without the statute, there is the element of notice, when you talk about things that are outside of business establishments, and that could be there. So, I mean, I'm not saying that there's not the elements of notice that's there. That is certainly something that's inherent within the common law and within the cases. But when we put within the complaint that there is failure to correct the condition, to inspect it, to maintain, all those types of things, the notice element could be either actual notice or constructive notice. The fact that there was an allegation within the complaint that they hosed it, and that there was no evidence to support that, does not dull the negligence that's pled within the complaint of failure to maintain. Because constructive knowledge, which we believe has been shown here, because it was there for about 30 minutes. We know from the video that it was there that this condition, this wet condition, which was wetness on the water on the paint stripe, was there for 30 minutes.
It was there before Mr.
It was there before he came in. It was there after he came in. And so that is constructive knowledge. This court, and I'm not sure if I cited to this, so I apologize if I didn't, but this court's Odrago decision very recently basically said trial courts can't make that determination anyways. Of how many minutes there is. This court really didn't do that. This court said that there just was no evidence of constructive knowledge. And the trial court blended that with this concept of open and obvious that said, well, because it would have been open and obvious to the plaintiff coming in, should have been coming out, and therefore there's no liability.
The open and obvious thing, isn't that more, did the trial judge conflate that? I mean, yes, there's water, but the issue, your position, as I understand, is the danger is the line, the yellow line is slippery, and so that's not really open and obvious.
Right, and it's even beyond that, because there's very clear testimony by my client that he didn't see the water coming in. And so there was not a situation where he was aware that there was this dangerous condition.
How does he not see it? I mean, if it's there, it's there. I mean, he may not see it, but I mean, is that imputed to him that he must know it's?
It could be, the jury could do that, absolutely. But I think the cases are very clear that open and obvious, when it is something, especially when it's something that's going to be in walking paths that the store owner knows is going to be in walking paths, is something for a jury to decide. And so because of those things, I'm butting up on my time here. I will save the rest of my time for rebuttal. Thank you.
May it please the court, and again, with
I'm
my
sorry, I can't
deepest-
hear you.
May it please the court, Sandy Topkin on behalf of Winn-Dixie, and I do apologize again for the clothing mishap. I'd like to jump right into spats, because I think that
I'm sorry, you want to jump into what?
the spat case,
Oh, okay.
which was Judge Soud bringing up that there is a Supreme Court approved slip and fall complaint. Plaintiff had the right, and technically is supposed to use that complaint if there's one available. He chose to plead specific facts, which don't exist and cannot be proven. And if the evidence was looked at, there's not even a spigot in the front of the store. There's no hose at the Winn-Dixie. And the manager said, no, absolutely nobody could.
Is the slip and fall complaint that you reference based on section 768.0755? Which shouldn't apply here, correct? Because it was not in the business establishment?
In the same sense that we would not have constructive notice because of those plus factors, it's not in our business establishment, which is why we have no control and no duty to the plaintiff.
Well, why did you put a cone outside then on the parking lot if you don't have a duty?
Because anytime an employee goes to the parking lot and there's an injured person laying in the middle of the road with a broken hip waiting for an ambulance, we put a cone out because we're there. We don't have any control over the property. We have
So shopping carts out in the parking lot you're not responsible for?
we have an unrestricted right to use the property. The landlord in this case owns the property, built the property, and set forth the terms, and we have a lease, and the lease speaks for itself, and my argument was
Isn't there case law, though, that discusses you should have a concurrent duty to maintain the parking lot, or no?
No, not in the situation where both are owned by the same party. In that situation, we were dealing, that case that I'm familiar with dealt with the landlord delegating the parking lot areas to the tenant. So the landlord, as the owner, had a non-delegable duty.
So what if one of your shopping carts kind of ran into my car in your parking lot? You're responsible for that, correct?
We could be, yes, depending on the causation of it. But this is not an act that we pushed a cart or did anything.
I understand that.
And we specifically, in a situation with two educated parties, a landlord and a tenant, they were free to negotiate the lease any way that they want. And it's an issue of law, what the lease says.
Well,
for the
whose
court.
duty was it on this one? You agree there is some duty owed to the invitees, right?
Yeah, Winn-Dixie had a duty to keep rubbish and trash out of the entrance.
Okay, all right, I'll ask a better question. In this specific scenario between Winn-Dixie and Cortez, who had the duty to keep that area where Mr. Sampson fell, to keep that reasonably safe for the customers?
The lease agreement clearly and unequivocally states the landlord.
Cortez.
Yes.
All right, so when the trial judge makes a finding in that separate order in that regarding Cortez, that's not correct. I mean, it's illogical to me that your side has no duty and they have no duty.
Well-
Somebody has a duty to keep that area safe.
If there's a dangerous condition.
Okay, okay, I don't want to dance on the pin with you. I mean, at some point, any customer walking into the Winn-Dixie should have the belief that somebody has to maintain that premises in a safe condition.
In a reasonably safe condition, yes.
All right, a reasonably safe condition.
Yes.
Right, all right. So this ruling that neither Cortez or Winn-Dixie owes any duty to Mr. Sampson is politely inconsistent with,
Could be, however, in the order for Cortez, it says, putting aside that issue.
okay. I think I'm wasting your time here when we're having this esoteric debate.
I don't dispute
I'll make it
that-
easy for you. One of the two of you had a duty. Whether it was breached is why we're here. But I don't want to go back and forth with you
Yes.
about, you can't just say, well, not me, look at my lease, and them say, not me, that's Winn-Dixie. Somebody had a duty. Whether it was breached or not, you guys are happy with the result. I get it. All right, let's move on. Forget the last 2 minutes I talked.
No, I appreciate the questions.
you?
I believe that the argument of the yellow line was never pled in the complaint. So,
That's what Judge said. Well, the element it was hosed off, and there's no
Correct.
evidence of hosing. Therefore, we weren't negligent because we didn't do any hosing.
but it didn't spell out the yellow line as being the cause, as the yellow paint being the cause. It just says he stepped off of the sidewalk into the lot and slipped and fell.
So the trial court says that it was undisputed that the concrete was wet from humidity. Was that undisputed?
Absolutely, the photographs that we supported to the court and the video of the fall.
So there was something in the record evidence that talked about humidity causes wetness on the, where did that come from?
It was on the incident report, which was provided. It was on the customer statement by Mr. Simpson, and there was an affidavit filed by Don Strobel, the store manager. It's
So do you
one-
agree it was wet?
Yes, absolutely.
Okay, so it was wet, and was it wet before Mr. Sampson came to the Winn-Dixie store that morning?
Yes, sir.
Okay, very good. All right, go ahead.
So, with regards to a situation such as this, there's some threshold issues that we must look at. We must look at if we have the ability to control the area, which is defined by the lease, which we stand on our argument. If we don't have control under Kaufman,
So are you saying if anybody was to make that area safer, reasonably safer, it was Cortez that morning?
I stand on my argument in the brief, yes.
So that's a yes.
Yes. According to the Phillips case, when a lease is clear and it expresses the relative duties of a landlord and a tenant, it's an issue of law for the court. So the interpretation of the lease is an issue that is for the court.
Is that what the trial judge decided here? I mean, if I'm understanding where you're going, you're saying for us to have any liability towards Mr. Sampson, there has to have first been a duty breach, cause, et
Yes,
cetera.
Your Honor.
And if
That's
we
what-
have no duty, then there's no reason to have much further discussion on the Winn-Dixie. This is more of a Cortez versus Sampson scenario.
If the court interprets the lease consistently with me,
Well,
yes.
that's what you're arguing, isn't it?
Yes.
Okay.
I said if the
I'm
court
just not making
agrees-
all this up.
No,
That's
no,
what
I'm
you're
saying if the
arguing.
court agrees with my argument,
Yeah,
yes.
you're arguing that, look, we can't be liable here as a matter of law because we owed no duty to this person at the location of where he fell.
Right, 'cause we
That's
had-
your argument, right?
yes.
Okay, and if that's correct, and it's a matter of law, then you wouldn't have any then the result is correct, whether there was a circuitous route taken by the trial judge or not.
100% accurate.
Does the lease require you to keep entryways and delivery areas adjoining the building reasonably clean and free from rubbish and dirt?
Yes,
Okay.
this was water.
Okay, so you wouldn't consider that,
And
having
the
to keep that,
Now, the entrance
Clean or dry?
of the door, and there's actually a case directly on point about what the entranceway is. It was a Winn-Dixie case with a piece of wax that was actually on the threshold, sticking on the threshold, and the court found that that was in the duty of Winn-Dixie because that was the entranceway, the threshold between the common area and the demise premises. and that's what the common definition of an entranceway is. We have, after the entranceway, you have the sidewalk, then you have their ramp, and then you have the parking lot. Sidewalk, ramps, parking lots, we have nothing to do with.
The yellow line was in the parking lot?
Yes, and that was painted on the entity with the duty to do that, the responsibility for drainage of the parking lot, grading of the parking lot, striping of the parking
You
lot.
did, I thought Mr. Lee said it was on the sidewalk.
It was not on the sidewalk. The video speaks for itself.
Okay, so we have a line that's either on the sidewalk or the parking.
There's no lines on the sidewalk, Your Honor. It's unequivocal that the line is in the parking lot on the asphalt.
You did say that though, right, didn't you?
I believe that he did.
I mean, today, in the argument.
Yes,
I'm
he
not-
did, and that's-
I'm not maligning his character, I'm just saying, I want to make sure I heard him correct, that's what I understood him to say.
He did say it was the sidewalk, but the evidence unequivocally shows that it was as he stepped off of the sidewalk into the parking lot,
Which would bolster your argument that we're not responsible for the parking lot.
we don't have the ability to control, yes. Again, the Publix versus Jeffrey case, which I referred to earlier, lease makes duty an issue of law. The
You're
intent-
closing in on your last 30 seconds here.
Okay.
I assuming you guys are splitting it 10-10, so.
Yes. So I would end with the argument that open and obvious is always a question for the jury. It's not. And Judge Sowd recently decided that in the Nancy Jackson case, which I find to be exceptionally persuasive. In the Nancy
You're
Jackson,
going to say exceptionally well written, we can wait.
it was eloquent.
Yeah, he's
Couldn't
good
have
looking
written
too,
it better
right?
myself, even if I had AI to help. But the seriousness is that in that particular case, we're dealing with an 1.5-inch raised sidewalk. And the issues that were considered in that case, that it was so minor, so obvious, so ordinary, so innocuous, and so inherently dangerous that there is no duty to do anything.
He said all
because
those things?
it's not inherently dangerous. And I would ask this court to follow the Jackson case. I would suggest that morning dew is 100 times more ordinary than a cracked sidewalk. Everyone has morning dew on the grass when they wake up every single day in Florida. It's the cold air at night and the heat in the morning creates dew. It's a natural condition.
We gave you an extra minute. All right, you can step. All right, thank you, counsel.
Thank you, Your Honor.
Yes, sir. Let's put it up to 10 for Mr. Rader. And we'll give Mr. Lee an extra, at least one more minute, depending on how long, Mr.
Thank you.
Go ahead, counsel.
Thank you. Good morning, Your Honors. May it please the court, Jack Ryder on behalf of Cortez. Let me start off, Judge Sood, with the point that you raised, which I agree with completely and I believe is dispositive in this issue. And that is that when we look at what the plaintiff pled as a theory of their case, they never were able to establish that as a theory, and that was that somebody was hosing down this property. And the problem for the plaintiff, and the reason why the summary judgment should be affirmed, is because, as Your Honor noted, that cabins the allegations. The plaintiff is the master of their complaint. When they come before the court and they assert that there was a hosing down, what they're essentially arguing is that somebody, whether it be Winn-Dixie or Cortez, created a dangerous condition. So they ventured forward under the theory that this was a danger that was created by the property owner or the lessee.
So it's not a constructive notice then, because we did it. We're on actual notice because we're the ones that did it.
That's the theory that they set out to establish. And the problem is, as Mr. Lee very professionally admitted today, they never were able to establish that theory through evidence. And so when and it's very well settled under Florida law, you know, in this case, in this court, the Olson decision said a primary purpose of summary judgment is to isolate and dispose of factually unsupported claims. When the claim advanced by the plaintiff is in itself unsupported because it's not, the evidence doesn't fulfill it, and there's never any leave to amend to establish an alternative theory, that constitutes a basis for summary judgment. And here, and that's, again, Judge Lambert, as you pointed out, plaintiff endeavored to establish this as an actual notice and as a condition created by the property owner or lessee. either one, but they never proved it. And we see that throughout the allegations. And, you know, if we look at the record at 171 through 176, the second amended complaint, and even throughout, even the presentation throughout the case in the pleadings, it was always about this notion of the hose being used. And then, of course, the evidence established that there was no hose or spigot used. There was an affidavit provided by a Winn-Dixie employee, the record at 548, establishing that there was no hosing done. Plaintiff admitted that this wasn't the case. And, you know, when we talk about what this case is sort of about in terms of the theory that was ultimately advanced, you know, we've seen it in the briefing. You know, the briefing attempted to bring up an argument that really wasn't made below, and that is whether or not this was either an unreasonably slippery condition or a transitory foreign substance. And the difficulty in trying to kind of maneuver around these different theories is that none of them have been established here by evidence.
And we don't have a transcript of the summary judgment hearing in case things took a different turn at the summary judgment hearing.
That's correct, which of course would fall on the burden, would fall on the appellant, who has failed then to provide an adequate record to support such a
So
position.
this line was in the parking lot itself, so you do agree that that's your responsibility to maintain that, correct?
We don't agree with that, Your Honor, but I'm going to say a couple of things. Number one, with respect to whose responsibility it was, I rest on our brief and on the lease, and that's a de novo standard, and I think the court doesn't need to get there. The court never needs to get to this notion, well, was it Winn-Dixie or was it Cortez? This court can avoid that completely because of the circumstances here and the undisputed
So
material
we got
facts.
there, though.
If the court did decide to go there, then I would submit that based on the lease agreement, that the responsibility would fall on Winn-Dixie because, I mean, the video is, I believe, quite apparent as to where the line was in relation to the entryway. And the lease does talk about the responsibility of the entryway falling on Winn-Dixie. But again, I don't think this court needs to ever get there or attempt.
I mean, we understand, Eric, but.
Yes, Your Honor.
The line is somewhere, right? It's either in the parking lot or
Sure.
on the sidewalk. All right, you're the third one. Where he says sidewalk, he says parking lot. Where are you going on this?
Well, so the line is not in the parking lot. If you were to look at the video, I'm sure the court has, but when one looks at the video, it's murky because you have this exit and there's the line, and it seems to be in this sort of zone between the parking lot and
Coming out, going
as it's
down.
coming out.
Who put the line there?
I don't know that that's in the record, Your Honor. I don't know.
It's your parking lot, correct?
Well,
Is it your building?
It's our building.
It's your building, your parking lot?
Well, you know, it's interesting. The parking lot's, I
So
guess,
Cortez doesn't own the parking lot?
I guess it's a common area, in a sense, in terms of responsibility. But I don't know the answer.
Who
Judge.
owns the parking lot?
I will submit that we may own it. I don't know. I don't have the deed in front of me. But in other words, the point I'm making, Your Honor, is I don't think the line is in the parking lot. I don't know who put the line there, to be honest. I don't think it's in the record. But the court doesn't need to get to that issue because...
I understand we don't need to get there, but so you don't know who owns the parking lot?
Well, no. I'm going to acknowledge that we own the parking lot,
Thank you.
okay? What I'm suggesting is I don't know who has responsibility for the line. I don't know who put it there. That I don't know. And I don't think the record displays that. But going back to, if I may, the issue of the point of the line, you know, what I'm hearing today from counsel was this contention that the line was slippery. There's no evidence that this was a slippery line. In other words, this wasn't a circumstance.
Slipped out.
Right.
But people, again, people slip. You know, there's plenty of cases, as Your Honors well know, that say the fact that somebody falls does not mean that there was negligence.
Is that an issue for the jury, though?
Not necessarily, Your Honor, and here's why. There's a property owner or lessee has two obligations. One, to warn of dangers that are known, that are latent, and two, to maintain the property in a reasonably safe condition, reasonably safe, okay? Whether or not the line was slippery does not necessarily mean that it was unreasonably slippery. And the dilemma here is that, as the court pointed out, and I believe correctly so, it rains in the summer, there's humidity. It was undisputed that it was humidity that caused this, and that was established by the affidavit of the manager of Winn-Dixie. The fact that there was no evidence of anything else that could have caused this water to occur. So the concept of the fact that somebody slipped on the line doesn't mean that it's a dangerous condition, because that would have to mean it was unreasonably slippery.
Is there any significance to the fact that, from the record, there apparently was no no prior slip on this line?
Extremely significant, Your
How
Honor.
so?
Well, here's why. And by the way, that's established by the Strobel affidavit at the record at 775, by the Cortez response at record 145, by Winn-Dixie's response to discovery at the record at, I believe it was 549. There was never an issue with regard to slipping on this property, on this line. And even the plaintiff testified, who had been coming to this area once a week for the last 5 years, at the record, that's his deposition, excuse me, at pages 22 and 23. I don't have the record cited in front of me, I apologize for that. But in his testimony, the plaintiff acknowledged that he had been going to this store weekly, and he had walked, Judge Boatwright, I think you pointed out, that he walked over this area a few minutes before the fall. So we've got an individual, there's no evidence of a prior fall, Judge Lambert, which goes to the heart of the fact that this was not an issue where we were on notice of some.
Did he walk on the line itself coming in, or if he walked by it on the non-slippery part, that's neither here nor there at this point because it's slippery on the line? That's his argument.
That's a fair point, Your Honor, but I would also submit that if there was any humidity on the floor that was showing a dampness, he walked over that area and therefore was aware of the fact.
He should have known it was wet.
It was a wet area. He walked through a wet area.
Correct, and therefore he knew or should have known, which goes back to the fact that this was an open and obvious condition. And, you know,
I mean, it's open and obvious because it's wet, there's no puddles, but it's not open and obvious that the line is slippery when it's wet. I mean, isn't that the contention to some?
Well, that's the
contention we're talking about today.
That's the contention we're talking about today. That wasn't the contention we were talking about below in terms of the pleadings and the sufficiency of the evidence. But I'm assuming for the sake of our discussion today that we were talking about the line being the slippery source. That still, respectfully, doesn't make it unreasonably slippery. There was no expert witness to say so. There was no evidence regarding an improper coefficient of friction. And that comes back to whether or not the property owner or lessee, whichever may have had the duty, did in fact, were they aware of the existence of an
We had no
unreasonably...
reason to present expert testimony to show it was not slippery because that wasn't how it was postured at the time of the summary judgment hearing.
That's exactly correct, Your Honor. Had this case would have been entirely different had the plaintiff, the master of their complaint, Judge Sood, as you pointed out, had not chosen to cabin their claim under this notion of it being a danger that we purportedly created by hosing down the property. Once they ventured off that path, they had a duty to establish that, and by not doing so, this court, as a result, should affirm the summary judgment unless there are any other questions.
No.
Thank you.
Thank you, Counsel. All right. Give Mr. Lee an extra minute.
Thank you, Your Honor.
If you want it. I mean, you got 6 minutes, basically.
May not need it, Judge. I just wanted to go just a couple points. One, I did want to come back to Judge Soud. I looked at the complaint, and paragraph 6 of the complaint is at page 48 of the record. And it does include, mind you, it does include the hosing down.
Second amended complaint, though.
The third amended complaint, Judge.
The third?
Correct. That's the complaint that. But I will say that this is the. It's the same allegations that were included within all of them. So paragraph 6 says, on this date, plaintiff encountered a slick and saturated strip of paint located on the sidewalk. Now, of course, it does say that had been hosed down during the time he was shopping, which caused him to slip and fall. And so now, mind you, I've already said that no evidence that it was hosed down. But from the beginning, the allegations were that it was the slick and saturated strip of paint that caused him to fall. And so from the beginning, that's the allegations of it. Now,
But how it got wet.
how the water
was
got there,
alleged.
I agree with you.
And when it got wet. was
Correct.
alleged.
But the allegations of I would say that the operative allegations are that there was a slick and saturated strip of paint that he slipped on. Now, he proved, we believe, through the knowledge of it, that it was there for at least 30 minutes, according to the video, and according, frankly, to they didn't dispute that. Neither defendant came in and said, no, it really was actually 5 minutes, or it was less than a minute. They didn't dispute that. And so we have a condition that was there for at least 30 minutes that was wetness, water, on it, and that made a slick and saturated strip of paint, and my client stepped on it and fell. That's the evidence, and I don't believe that's disputed in this case. Now, they can argue...
So is your argument that it doesn't matter how it got wet?
It doesn't.
I mean, it would matter for actual notice.
It certainly would, but it doesn't. But there's case law that I've cited to specifically in my initial brief, which is before and after, that says that a plaintiff does not have to determine what specifically he slipped on, which makes sense because
They slip in a Publix, or they don't know how the.
we don't know. They might not
who
know.
spilled the stuff out.
They might not know whether it's water, whether it's juice, whether it's something. They don't have. There's nothing that Florida law says that you have to establish how that got there.
You have to say, that customer 10 minutes ago is the one that spilled it, and
Right, but the trial court mandated that. The trial court talked in, frankly, both of the orders about, and the court focused on that. Well, plaintiff doesn't know who did it. Plaintiff doesn't know how it got there. All those types of things, in my view, Judge, do not matter. It matters in the sense of facts. You're going to have to bring up to the jury. They're certainly going to bring up that, hey, look, we didn't do it. It was something that was there before. But it doesn't matter in the sense of whether they get summary judgment on that.
Ordinarily, I might be inclined to agree, but we're left with the complaint in the case. But let me, we've talked about that.
Yes, sir.
I'm gonna ask you one more question, I'm gonna leave you alone. Where is the line? In other words, let's take out hosing down and all that. If it's raining, if it's dew, if it's just got wet, where is the line in making the property owner or Winn-Dixie, the store, the insurer for an unfortunate incident? In other words, if it rains in Florida and the paint strip gets wet, where do we draw that line?
This court has drawn the line in certain circumstances where, and other courts have too, as far as minutes. They those typically involve when you're inside a store, and what I would say to the court regarding that, there are cases that talk about natural conditions. And those cases talk about natural conditions in the sense that if a property owner knows that natural conditions exist on their property, and that natural condition through the circumstances can be a dangerous condition, then they have the duty to monitor that. They have the duty to maintain that. And just because we all know that it rains outside, but going to Judge Lambert's point, there is that he was talking about, there wasn't a puddle there, right? But would that change the analysis of the court? I don't think it would.
What about Judge Lambert's point that nobody has slipped on that, or they had no knowledge that anybody had ever slipped on that area before?
Sure, that goes to, if this were which we don't think it's under the transitory foreign statute, it goes towards regularity. There wasn't anything there where we feel that doesn't apply. But even if it were to apply, just because someone didn't slip on it before doesn't mean the first person that slipped on it get a free pass for that.
But how does the defendants then know it's a dangerous condition if nothing has ever happened? Let's say it's been 20 years and never had that happen. How do they know it's a dangerous condition so that they need to take steps to make it not dangerous?
Sure. Well, and what I would say, Your Honor, is that the knowledge of that it is actually a dangerous condition is not necessary. They don't need to know that they actually have created a dangerous condition. And so they are imputed with that, with the knowledge that, and we know that someone, whether it's Cortez or Winn-Dixie, created that line.
Right, but they
did that.
It seems
So-
like we've come past the hosing, or your position is not the hosing. There is something there that was not created by Winn-Dixie or Cortez. There is
The water.
There is moisture there.
Right.
It doesn't seem to be that somebody spilled something there. It's just wet because it was just wet at that time.
Right, and yes, I mean, look, the court can make a line on that, but I think that, especially when you're talking about a clear path, a pedestrian path that people are going to use to come in and out of your store, then that's where the courts look at it and say, that's jury questions that you talk about it. We would ask, thank you for the time, and we'd ask for you to reverse. Thank you.
Thank you, Mr. Lee. All right, well done. All right, gentlemen, have a safe trip back to wherever you're going.